I'm really, truly honored to be here. I grew up in Vancouver. I left 25 years ago, which makes me, I left very young. That's actually not true, but that's my story and I'm sticking to it. But I was truly thrilled to be invited here by Dean Bobinski and the faculty at UBC. And part of the reason why I was really happy is because when I read about Mr. Mawhinney and his contribution, I saw that he was the what in the legal ethics world we really rely on, which is lawyers who are exemplars of professional practice, but who also engage with the academy and thoughtfully with what it means to be an ethical lawyer. And I will say that actually, in my view, British Columbia right now is very blessed in that regard. In our legal ethics world, there are several lawyers from the city, John Hunter, Gordon Turriff, Gavin Hume, who are engaged with us. They come to our conferences. They talk to us about the issues, and it makes a huge difference because I can talk and think about all of this stuff from my ivory tower. Actually, it's a plain gray room. It's kind of ugly, but from my ivory tower. But I can't do the work that I do without talking to lawyers who are still engaged in the practice of law. And in this particular case of this paper, I will note up front that I was greatly assisted by the members of the Canadian Bar Association Professional Responsibility Committee who all read it, and in particular Malcolm Mercer, who's a lawyer at McCarthy's in Toronto, who he's always there as a person to talk to and was helpful here. But on that point, my talk today is on the lawyer's duty when advising clients. And I'm going to start out by talking about what this issue is, why it's something that we ought to care about as a profession. I will then talk, hopefully briefly, although as an academic this is the stuff I love, about conceptually why we would understand the lawyer's advising role in a particular way. I'll then go through, and this is your CLE point, so make sure you take notes here, on what the law governing lawyer advising is in Canada, with a focus on the BC Code of Conduct. And then I'll talk about law reform, and in particular some areas in which we could think about changing the law to better capture what I think the lawyer's duties are when advising clients. So, but to start, and this is, of course, how we always start as lawyers, with a definition, which is, what do I mean when I'm talking about advising? And I have a relatively specific, I don't think controversial, but specific idea of it, which is that it's the guidance or opinions that lawyers provide to their clients in circumstances that are governed by confidentiality. It's not advocacy, it's not negotiation, it's not intersection with third parties. It's when someone comes to you and says, can I do this? And the lawyer gives them opinion or guidance as to what they can and cannot do. Of course, one of the notable features about legal advice, which is known to all of you, is that legal advice makes a difference to a client's legal position. When you give someone advice, it's not just sort of information that they can take away and do what they like with, although it is that. It's something that changes their liability and negligence. It changes their liability criminally if they can say that they did what they did on the basis of legal advice. The leading case on this, or the one at least that I always cite, is the Pinkerton and Falauca case that involved the giant mine in the Northwest Territories, where the Northwest Territories was found by the Supreme Court to have acted unlawfully and to have acted negligently, but was not held to be liable because they did what they did on the basis of legal advice. Some examples, nothing particularly surprising here, but advising is something that lawyers do all the time. These are probably more big firm contexts. There would be other contexts as well, but obviously in the tax planning, with corporate boards, the obligations and opportunities that a corporate board has, securities law, and I think the biggest one, and this would cut across practice areas, is in the area of regulatory compliance, whether you're doing that which the regulations require you to do or what room to maneuver you have within the regulations. And in the litigation context, the one place where lawyers advise, in the sense that it's not subject directly to public scrutiny, is with respect to people's disclosure obligations and what falls within the privilege. So there are a number of ethical issues around advising, but the one that I'm focusing on tonight is with respect to the balance between a lawyer's duty to provide accurate or objectively reasonable advice to clients and their ability to shape their advice to facilitate clients' goals. To write, as one person, David Luban, said in criticizing the torture lawyers, who I'm going to talk about in a minute, he said, there's a problem when lawyers write an opinion with all the swagger, a brief writer's swaggering self-confidence. And so the question would be here, how much swaggering self-confidence can you have in giving a dubious opinion, as opposed to how much should you be focusing on trying to simply provide your client with the best answer, all things considered. Now, why this issue has become more current is, I think, in large part because of the torture lawyers of Washington. If there is an ethics scandal that has occupied certainly American lawyers, but also academics who write in the legal ethics field, it is, in the last 10 years, it is the case of the torture lawyers. So for those of you who don't spend your days in that dull gray office that I occupy, the torture lawyers were lawyers at the Office of the Legal Counsel in Washington, which has been described as the most powerful branch of government you've never heard of, whose job it is to give advice to the president on the legality of actions that he is taking. Under the George W. Bush administration, that tended to involve things like warrantless wiretapping. It also involved the use of what they called enhanced interrogation techniques, or what we might call torture. This is, by the way, an ongoing issue. The Office of the Legal Counsel advises the Obama administration on drone strikes and have been actually subject to some not dissimilar criticism as to what happened here. In any event, there were many, many memos written by the OLC, but the one that became the most notorious was one written by John Yoo and signed by Jay Bybee, which was notorious in part for its result, which essentially wrote down torture to, as long as you haven't actually killed anyone or almost killed them, you probably haven't tortured them, but also for, frankly, the surprising nature of the legal reasoning used to reach that result. And I could actually spend my whole talk going through different examples, but I'm going to focus on one, which I call the LSAT failure example. And what they did there was they said, and torture is, of course, legally forbidden in domestic law in the United States and also legally forbidden in international law. And under the domestic statute, it defined torture as things that involve severe pain. And so one of the questions dealt with by John Yoo and Jay Bybee was, what does severe pain mean? And they thought, well, we'll go and look at a database and find an American statute that uses the word severe pain. And they found a Medicare statute. And of course, what this statute dealt with was with whether you could give someone services at a hospital and the government would pay for them. And they said you can provide those services without asking too many questions if a person's suffering organ failure or risk of death. And they said, well, obviously someone's not going to come into hospital and say, my organs are failing, I'm about to die. So you're going to have to figure out whether that's happening. And one sign is that they're in severe pain. So the statute said you can provide services in this situation. And the therefores are from John Yoo and Jay Bybee, who said, therefore, severe pain only arises when you are at the level of organ failure or risk of death. And as one of my students said a couple of weeks ago, they obviously never went through childbirth. And then they further concluded that unless you bring someone to the point of organ failure or the risk of death, it is not torture. There are a number, as I said, of other examples. One that people like to cite is they wanted to say that necessity justified torture, but this being a Republican administration, they were careful to add in the memo that necessity would justify torture, but not someone who provided an abortion illegally to save a woman's life. They wanted to make sure that that division was maintained. This memo did not fare well in the court of public opinion or either in the court of the legal profession. And I have noted at the end there the one sort of defense you see, which is Richard Posner's son, Eric, who's an academic, said, standard lawyerly fare, routine stuff. Other people, and in fact, really the majority, including, and it wasn't a political issue because the OLC remained Republican for many years after this, but the OLC itself repudiated the memo. The Department of Justice Ethics Review said that it has significant flaws. My mentor, David Luban, was a bit more blunt and said the conclusions range from the doubtful to the loony, and testified to that effect before Congress. And Peter Brooks says, textual interpretation run amok, less lawyering as usual, and the work of some bizarre literary deconstructionist. I'm going to talk a little bit about the ideas underlying the defenders and critics of the torture lawyers, but I do want to bring this issue home, and this really is the reason I felt motivated to write this paper. You know, why this paper, why now, is because of the Schmidt case, which I think a lot of you will be familiar with. It was on the cover of the CBA magazine, I think the last issue. So Edgar Schmidt has brought litigation against the Department of Justice, arguing that the minister and the deputy minister have failed to fulfill their legal duties. Whether or not that is the case is not of particular concern to me. I mean, it's a concern to me as a citizen, but not as a legal ethicist. But the reason it's of interest to me is because in his litigation and in the documents that have become public as a result of litigation, there is a particular legal position apparently being taken by the Department of Justice in advising the minister, which I think would be fairly described as aggressive and as closer to advocacy than to a more dispassionate view. The Minister of Justice has legal duties under various pieces of legislation, the Bill of Rights Act, the Statutory Instrument Act, and the Department of Justice Act, which require the minister to report to the House where a proposed bill, and I said legislation, but it's actually a bill, is inconsistent with the purposes and provisions of the Charter or the Bill of Rights. And the Department of Justice has done two things in interpreting that. The first is they've said that it has to be clearly or manifestly inconsistent, although those words are not actually in the statute. And they've also said, and the actual language in the documents, is that you will only be clearly or manifestly if you are at the far end of 81 to 100% certainty that the opposing side would prevail. So you've got 5%. Now, this litigation is still before the court, so it may be that a judge will say that, in fact, that's a legitimate and reasonable interpretation of the legislation. Maybe. But the point for my purposes here, and this really goes to the criticisms and the defenders of the torture lawyers, is there's a couple of ways you can think about the lawyer's role as advisor. Of course, I'm being an academic going to reject both. But one way is to say lawyers are advocates. When a client comes into your office and asks for advice, your job is to get them from point A to point B, just like you would in a courtroom. And that's, I think, when Eric Posner says standard lawyerly fare, routine stuff, that's what he's saying. This is just what lawyers do. They advocate. And the fact that this is advising doesn't change that role. The response to that has been people who criticize the torture lawyers, who are mostly academics, well, they're both, but the academics who've written about it, say no, that when you're advising clients, in fact, you're the opposite of an advocate. You're actually like a judge. And so they say things like, the goal of independent professional judgment is not to serve the client's interests, but to provide an objective analysis of whether a proposed action is wrongful and therefore a risk to society and third parties. So on the one hand, you see this kind of behavior from a segment of the bar, which is, and I do actually think that is not the norm. I want to be clear about that. But it has this more advocacy type role. And then people pushing back and saying, no, you have to be the opposite. You have to adjudicate. And so the first thing I'm going to deal with now is saying, well, what's the actual answer to that? And then when I look at the law governing law, talk about whether we give enough guidance to lawyers about what their duties should be when advising, whether we are able to create within the profession a culture that facilitates this view of advising, and whether we have sufficient tools to sanction those lawyers who engage in improper legal advice. I feel like I'm teaching, so actually there's a part of me that wants to stop and let you ask questions, but I must not do that. You are not actually my students. You're much better dressed than my students. I'm going to take a brief digression now to talk about the conceptual point and delve into some ideas about why we have a legal system, or what a legal system is, and the role that lawyers play in it. Because I think if you want to understand what lawyers do when they advise, you need to step back to the whole question of what is it that lawyers are doing in a legal system when they're having this advising role, particularly when you take into account the fact that we give such authority to what lawyers do when they advise. And the position I'm going to take here for the, those taking their philosophical playbook out is my perspective is one which is a kind of sort of positivist, but also informed by an idea that law has a moral structure and that law as a form of governance is fundamentally different from a dictator's series of rules. So there's things that something has to have or a system has to have to be properly called a legal system. And what I mean by that, and now I'll make it a little bit more straightforward, is law does a couple of things. When you have a system of legal governance, there's two basic things that you're doing. One is you're saying, okay, we all really disagree on what the world should look like. They profoundly, deeply, fundamentally do not agree with each other about the right way to live and the right way to be. But we want to live together without killing each other. We want to live together in a way that we have structured means of deciding what the rules governing our behavior will be, and that we can access those rules. And that's law. So law we can be called a form of social settlement for our moral disagreements. In addition, though, and this is the idea of rule of law with which, as lawyers, you will be deeply and intimately familiar, when you have rule by law as opposed to dictatorship or simply exercise of raw power, you are assuming and respecting people in a very particular way. You are assuming that they are reasonable, that they have dignity, and they have autonomy. And there's a number of features of law that do this. The key ones for our purposes being, of course, our system of dispute resolution, that we have courts that you can access and go to. Another feature, though, is that we make law generally and publicly available because we treat people as having the ability to comply with it on their own. We don't actually rely in our legal system on going out and making people do it. We trust them to do it themselves. We trust them to actually, generally speaking, comply with the law's requirements. And in addition, we allow people, because we set the law up as a system of argument as much as a series of enactments, we allow people to engage with the law, to argue about what it means, to shift it, to change it deliberately through governance, but also to change it through simply the claims and arguments they can make about what it means. Now, if you think about that, what then are lawyers about? What's our role? And our role is, I think, a couple of things, most obviously, that follow from that. Lawyers are essentially the intersection point between the citizenry and the law. Because, and I was joking with the students, and I gave this talk today about whether they actually felt that they were more like the citizenry or more like the lawyers. But we can say to the citizenry, and I mean that term loosely, guess what? You get to engage with the law. You can argue about what it means, and they will say, okay, lovely, but I have no idea how to do that or what that means. It's lawyers who create the capacity for people to live in the legal system and to be part of that system and to actually access what it provides. They access law's social settlement and they accomplish the rule of law. They ensure that people can advocate in dispute resolution. They facilitate people's voluntary compliance. But they also facilitate people's ability to argue with and engage with what the law means. And I don't just mean in advocacy. I mean when they're talking to a lawyer about what the rules are governing their situation. Lawyers can help them have that engaged process. As I put in my more articulate notes, lawyers give the law force, but they also give the citizen a voice. So advising. We've now got law, we've got lawyers, and now let's get to the advising point. When someone comes into a lawyer's office and says, okay, I have occupational health and safety rules, I want to set up my facility in this way, what does that mean, can I do that? What they're getting from their lawyer is, first of all, access to information about what the law says, about what this social settlement that they've got means. They are looking for assistance in voluntarily complying with the law and not just waiting around to be caught, and engaging with what the law requires of them for making decisions themselves about what they want to do and within the boundary of maneuver that the law gives with how they want to proceed. In this way, lawyer advising is really distinct from advocacy. Advocacy is a central part of a rule of law society, but it's not what lawyers are doing when they're advising. But they're also not adjudicating. A person who comes into your office, you are facilitating their ability to live freely within a system of laws. And to see you as simply telling them what the law is and what they can do would be a fundamental misunderstanding of the lawyer's role. What that means, I think, for the ethical requirements of the lawyer as advisor is that your advice does have to be accurate. It can't be an act of wish fulfillment. Now, of course, accurate or objectively reasonable is a standard which is contextual. It's a standard which has a range of maneuver. It's not a claim to say, hey, lawyers, get it right. But it is saying that there are boundaries outside of which your advice ought not to fall. In addition, though, legal advice does have to facilitate decision-making by the client. It's not a question of the lawyer simply telling the client, hey, this is what I think and this is what you're going to do. It's a way of saying, this is what the law says, this is your situation, here's some ways that you can think about how to go forward, and they themselves can decide what they want to do given the information that they've been given. The lawyer's friend, and Charles Fried wrote one of the most famous articles, if not the most famous article in legal ethics, called The Lawyer's Friend, The Moral Foundations of the Lawyer-Client Relationship. And this article has great virtues as a piece of academic writing because it makes a pretty good philosophical argument, but ties it to a kind of whack analogy. And so you get a great situation that everyone has to take it seriously because there's a good argument, but the analogy is super bad. And so everyone wants to write about it and say how bad the analogy is. And so they've taught, because his argument is lawyers can do bad things for their clients because they're their friends. And he justifies that, so the underlying part's good, but of course saying you can do bad things for someone because they're your friend, immediately everyone says, well, no, you can't. You can't do bad things for someone just because they're your friend. And by the way, when people pay you, friendship's not usually the word that we would use to describe the relationship. However, having pilloried it, I'm going to do the next academic move, which is to say, well, yes, the analogy's bad and all of that, but guess what? It actually can be good. And it can be good because it's a really nice way of encapsulating the dual function of a lawyer when advising a client. Because in an ideal world of friendship, your friends don't just tell you what you want to hear, and this may tell you something about the kind of friend I am and make you not want to be my friend. But what it says is that when you're giving advice to a friend about what to do, you're empathetic to them, you're committed to their interests, but at the same time, you do tell them what you actually think. And if they're about to do something that's stupid or wrongful, you tell them that they're about to do something that is stupid or wrongful. And so while I think friendship is a very poor analogy for the lawyer as an advocate, I think it's actually quite a helpful one for the lawyer as an advisor. Now, I have two little brief, I've set up my claim. This is my claim for what lawyers ought to do when they advise clients, conceptually. I want, though, to address two, I think, arguments that can be made quite quickly against my point. One, I'm not going to convince you on the first one if you're not susceptible to be convinced, but I will, make my effort, which is the problem of indeterminacy. Because one of the arguments that's made in defense of the torture lawyers, and the one actually George W. Bush himself made, was, well, what does the law mean anyway? We don't really know what it means. It's just a matter of argument. There's no actually set meaning. And this is a view with some historical legitimacy. Of course, it comes from the legal realists who said law is what judges say it is. And more recently from critical legal studies folks who say law is power. It's not that you can reason through to legal conclusions. It's just social and political judgment, and the conclusion being the decision is not based on or determined by legal reasoning. So if that's the case, how do you require people to give accurate advice? How can you make that a meaningful obligation on people? My response to that, which I steal, basically, with citation, of course, from David Luban, is that yes, the law has a level of indeterminacy. That's partly one of the ways in which it respects our rationality. We're allowed to have arguments about what it means. We're encouraged to have arguments about what it means, and there is a way in which we let it be contestable. But it's moderately indeterminate. And one way to think about that is, first of all, that the legal system itself and those who practice within it, including, of course, most of you in this room, actually act as if the law has content. When your client comes into your office, you don't say, oh, wow, man, I don't know. What do you think, right? You have tools that you bring to bear to give your client advice. In addition, when we think about the law, if someone gave you a case and said, but, there's a secret code in here, and you have to discern it, play it backwards and see whether, Scalia is dead. That's academic fantasy. But, there's no secret codes, there's no hidden meaning. Law is at its best when it's all surface and no depth. And in addition, in our case law and in various areas of law, we act as if the law is determinate. I teach administrative law in my other life. And while when the court says a decision has to be correct, all they really mean is we get to decide, there is nonetheless clear authority in that area of law for saying there are ways in which we can constrain and judge and review decisions. And there are arguments that we can say are frivolous. There are things that are outside of what it is appropriate to say as a lawyer. In addition, and this may be the more important point, there's a way of doing law. Quite apart from any particular answer, there are things that I think it wouldn't be hard to get agreement in this room about as this is okay, this is not okay. If I said to you, there's a binding authority on this, are you allowed not to cite it in an opinion? No. Can you misrepresent what that authority says? No. Can you take an extremely unusual and esoteric and unconventional interpretation of that decision and not acknowledge that the interpretation is different from what most people would say? No. In other words, as lawyers, we have a way of doing law, and it's that as much as anything which constrains the indeterminacy of particular legal norms. It's what the Supreme Court in Dunsmuir, I'm sure for those of you who do administrative law, you love that case as much as I do. Heavy irony. There are margins of maneuver in law and a requirement that reasons be justifiable, transparent, and intelligible that can govern us. My second, I think, less potentially deep point or conceptual point is with respect to representing organizations. And this one I will give, he may not want full credit, but I will give full credit to Malcolm Mercer on because he pushed me on this point. Because he said, you can't be friends with the government. You can't be friends with a corporation. That analogy makes no sense here. And it makes no sense in part because, of course, governments and corporations and not-for-profits are not natural persons. We treat them as legal entities. But to say that a corporation has an ability to rationally engage with the law is to say something which makes no sense. In addition, organizational clients often, and by often I mean pretty much always, but say often so as to avoid argument, have public duties. They have duties to shareholders, they have duties to the public, they have duties to people who are using their services, which mean that simply doing what they want or what they prefer or what their personal goals are is never really an option for them. As clients, they tend to be powerful. They're often, as lawyers, our employers directly. They are often the sources of most of our business. And that makes it harder to retain some of the, makes it more tempting to become a facilitator of their wishes. And by who decides, my last point here, of course, organizations have clear structures of decision making. By who decides, I don't mean, gosh, I don't know who's going to instruct me here. What I mean is that it is empirically true that whoever is instructing you as a lawyer is not the same as your actual client. There is always a conceptual divide between the person who's sitting in your office and the actual interests that you're legally charged with representing. And so that creates a challenge to seeing the legal advice or the legal relationship as purely personal. What that means is that while as a lawyer for an organization, you're still not being an adjudicator. You nonetheless have more of an obligation to make sure that your advice is objectively reasonable, that if you're acting, say, for a family law client or someone, a personal person, an actual person. Okay, now for the CLE part. This is where you get a full hour, but this is the only part you actually have to listen to. What is the Canadian law governing advising? Does it work? Does it match what I've said, this idea that you have to give accurate or objectively reasonable advice, but nonetheless be focused on your client's interests? In particular, I'm going to focus on the objectively reasonable part. And to give you the summary version, in case you are unable to fully tune into this whole thing, is the law maybe does that, but it doesn't do it very clearly, and it could do it better than it does. Like all law governing lawyers, your legal duties as counsel tend to come from codes of conduct and from case law arising from your common law duties as a lawyer under contract, tort, and the fiduciary relationship. Advising is no different, and your first duty is the one that comes from the code of conduct. BC has now happily adopted the Federation Code, so all I had to do was change my numbers, and maybe a little bit more, but mostly just that. Your advice has to be competent. Competence says that you have to apply relevant knowledge and skills in a manner appropriate, basically do the thing that you're fit to do the job that you've been given to do in an appropriate way, given who you are and what that job is. In terms of advising, it says that you have to specify what your opinion is based on, the facts and circumstances that govern it. You must avoid bold and overconfident assurances. But, and this is an important thing, it does not deal specifically with a requirement that legal advice be legally accurate. And you will only be found to have been incompetent in instances of gross neglect or where there's a pattern of neglect or mistakes. There is a case there's not that many cases on this in the context of advising. There is a case from BC where a lawyer was disciplined for failing to read the results of a title search properly. That case would be unusual in the sense that it is a single instance of improper advice and it doesn't quite seem to be gross neglect. It was, of course, under the previous rules. And it's a little bit out of step with the case law elsewhere in the country, which tends to require the pattern of negligence. The next duty you have when advising is the duty of honesty and candor. It says that a lawyer must be honest and candid and inform the client of all the information known to the lawyer. It says in the commentary that includes being competent and that your opinion be open and undisguised. To my knowledge, there are no Canadian cases dealing with this provision, but it is the provision that was used with respect to the torture lawyers. By used, I mean found not to prohibit what they have done. Because when this provision was interpreted in the United States by the Department of Justice, they noted, first of all, that lawyers in the country who are found offside of this rule have generally been in a conflict of interest or violated other code provisions. No lawyer prior to the torture lawyers had been suggested to act improperly simply because the advice they gave was so bad. And from that, they decided that the duty of candor you have when advising is the same as your duty to the court, which, as many of you will know, generally only requires you not to make comments you know to be false or that you're reckless as to with regards to their falsity. And in the United States, recklessness means, and it might be similar here, but I'm just referring to that judgment, recklessness means a conscious indifference to the consequences of one's behavior or a conscious disregard of the risk. In short, as this rule has been interpreted in the United States, it does not prohibit you from giving bad advice. It prohibits you from knowingly and in bad faith giving bad advice designed to help your client get something they wouldn't otherwise be entitled to in law. Jack Balkin, who's a professor at Yale who has a kind of interesting blog called Balkanization, said this about it. He said, "These rules are set up by jurisdictions to weed out the worst offenders, leaving the rest of the legal profession to make entirely stupid, disingenuous, and asinine arguments that normal people with functioning moral consciences would not make. In short, assuming that this rule would be similarly interpreted here, and I think honesty and candor are generally subjective states. They're things that are true about you. And so there's a reason to interpret it as they did. And if you do interpret it that way, all it does is prevent the lawyer from knowingly giving improper advice. If you've convinced yourself that it's true, you'll be okay. The standard of negligence as a standard is much closer to what I'm talking about. If you give advice which is objectively unreasonable, you can be found liable in negligence. Objective reasonableness does have a contextual analysis. And what they will do, of course, is they'll bring in a lawyer who knows the area you work in, who knows the kind of work that you did, and that lawyer will opine on whether the advice you gave was negligent. There's quite a lot of case law on negligent advising, and what's interesting about it is lawyers are not found liable merely for errors or omissions. They are also found liable for errors of judgment. You don't just have to find the right law, you have to appreciate what it means and how it ought to apply to your client's circumstances. As the courts say, they don't require a standard of perfection. They recognize that you can make a mistake and not be negligent. But there are mistakes that, if they are viewed to be unreasonable, you will be held to be liable. Of course, negligence does not provide a complete regulatory tool, because you will only be found liable for negligence if your objectively unreasonable advice injures your client. In both of the examples that I raised at the beginning of this talk, the torture lawyers and the Schmidt case, the advice, if objectively unreasonable, was highly beneficial to the client and therefore would not, of course, lead to liability. And the courts have been clear on this. Unless the third party is one who will be within your contemplation at the time of the advice, i.e. a beneficiary to a will, you will not be liable even if your advice hurts that third party. I will briefly note, as part of my CLE theme, that there are other duties that apply to a lawyer when advising. Your advice must be free from a conflict of interest. If there's a substantial risk that something about you or your relationship to other clients or the clients that you represent would have a material and adverse effect on your advice, then you ought not to be providing it. Lawyers must not engage in activities that the lawyer knows or ought to know assist in or encourage dishonesty, crime, or fraud. This is a very narrow rule in application. It's basically applied where lawyers urge their clients to violate a court order. Those are the cases in which it's come up. In the tax context, tax planning is, of course, one of the areas in which stretched advice is most tempting. It allows your client to do two things. It allows them to avoid prosecution for tax evasion. It also allows them to report things on their financial statements that they wouldn't be able to report if the transaction wasn't arguable. There's some code word that they use. But the government has, of course, anticipated this problem, and so in the tax context, if you give advice which may prevent your client from being prosecuted for tax evasion, you yourself may nonetheless be subject for prosecution for the regulatory offense of giving advice with a willful, reckless, or wanton disregard for the law. And there actually has been a prosecution under this provision relatively recently. So that's the law governing lawyers. That's what right now governs our behavior when we advise clients. What are the gaps in this? As I've said, the honesty and candor is subjective. Competence, first of all, I think maybe more importantly, doesn't speak to the obligation of advice to be accurate, and is only subject to discipline if there's a general pattern or gross neglect, and negligence only governs where the client is injured. In short, there's no clearly stated guidance provided to lawyers that advice has to be objectively reasonable. So, what ought we to do, if anything? Now, I'll note that my first point here is perhaps we ought to do nothing. And I used to know someone who was a fine gentleman who one of his favorite expressions, though he always attributed it to someone else, it was actually him talking. He said, "I'm against all change, even if it's for the better." And so I wouldn't say this is inspired by him, but look, I did work in the area of utility regulation, and if you work in the area of regulation, you have to be alert to the fact that regulatory change can make things worse, not just always make it better. The law of unintended consequences always looms large. So what's the benefit to doing nothing? It doesn't cost anything. It keeps the law client focused, in the sense of saying if you require lawyers to give advice in a particular way, they may be less assiduous in ensuring their advice does further their client's interests. And of course, there is the argument, I've made the argument that the law has a lacunae in it, but there is a countervailing position that it doesn't, that the law societies could interpret these rules to do what I've suggested. However, the issue I have is that I think there's a lawyer at the Law Society of Manitoba who said to me, there's three categories of lawyers here. One category is the lawyers who have no problem doing this. They know that their advice has to be accurate, and that's what they do. The third category, which I think is really the smallest, is the lawyers who don't care about their law being, the advice being accurate, and who are just trying to get their clients what they want. The second category, which may or may not be the largest, I don't know, certainly it has some members in it, are lawyers who are well-intentioned but uncertain, or lawyers who are under considerable pressure from their clients to give this kind of advice. I don't for a minute think the lawyers of the Department of Justice were anxious to provide advice that they didn't agree with, but it's not easy to say to your client, I'd like to give you that advice, but I can't. And guidance is useful to tell those lawyers what their duties are, but also for them to say to their client, well, gosh, I'd like to do that for you, but I can't. In addition, I think law societies discipline lawyers sometimes. But if we want an ethical profession, just like the legal system itself relies on voluntary compliance, legal ethics relies essentially, almost entirely, on voluntary compliance, and with having a culture that encourages a particular way of being a lawyer. And if you've worked in different cities, you know that different cities, different communities, different practices in the bar have different ethical cultures, and those are important and significant. And if we want to have a culture where we view advising as a distinct lawyerly function, where we say it's this particular kind of thing, it's not the same as advocacy, creating that culture, it's helpful to have rules. And of course, the most famous example of this is seat belts. Hardly anyone gets ticketed for not wearing a seat belt, but once you made it legally mandatory, everyone started doing it. And finally, the problem with doing nothing is that you hope that the torture lawyers will never happen here. But it is a source of some unhappiness to me that John Yoo remains back at Berkeley working as a occasionally interrupted with disruptions from angry students, but largely not. And Jay Bybee is now a federal judge. And while I don't see any particular, I never particularly want to see people go to jail, sometimes even when they've done really bad things. And so I wouldn't want them to see them go to jail. But nonetheless, it is disheartening to me that there is no public declaration that what they did was really wrong. And it was a violation of what we as lawyers hold ourselves up to, and it makes the profession, you know, I don't care about the profession looking bad, because I think sometimes we look bad for things that people just don't like other people to do but want them to do. But there are things that we ought not to suffer from, and that's something that we ought not collectively to suffer from. Another approach would be to say, no, this is like the hardcore approach. We'd say, you have to give accurate advice, and if you don't, in any case, we can discipline you. So you make discipline like negligence. I think this is a terrible idea. You know, the sort of RoboCop in me might like it, but it's, I think, a bad idea. And it's a bad idea for a whole bunch of reasons. The second one, I think, being the most important, that if you push a huge pressure on lawyers to make sure their advice is accurate, they will become adjudicators of their clients' interests instead of helping their clients realize their goals, which even in the organizational context is important. The first one, and my friend Alan Trelevin is here, so this might be, as a law society person, might be more concerned with this one, is you would have law societies having to adjudicate substantive cases. What would happen is someone has an issue with the conduct of a third party. They know that third party received legal advice. Well, rather than suing the third party, they can just go to the Law Society, complain about the legal advice, and get the Law Society to decide their case for free, except for paid for by everyone in this room. That's not a good role for the Law Society. It's not one that they can do substantively. It's not one they can do in terms of their resources. And it's also inconsistent with how we view professional misconduct, which is generally about some kind of professional misconduct in our tradition is viewed as a form of bad behavior. It's not just something we don't want. It's something that we will only discipline you for if there's some sense of culpability in what you did. And people can give inaccurate advice without culpability in that sense. The next option, which I mention only because it's how they do it in California, and you're in BC, so you should like how they do things in California, but I don't think you'll like this one, is they let third parties sue lawyers for giving bad advice. If your advice gets your client out of trouble, unfortunately, it might get you into trouble. This, of course, from a Law Society point of view, is cheap. It may arguably reflect what lawyers ought to be doing, but I think it's a relatively ineffective tool. It's ineffective because it would have, again, the bad consequence of undermining client interests, but also be problematic because, of course, it would only result in regulatory guidance or advice to lawyers insofar as claims like this could be sustained. And that means there'd have to be some kind of empirical connection that was demonstrable between the advice and the loss suffered by the third party. It's also, of course, a complex change to introduce because you'd need provincial legislation in every province to do it. So I don't think it's particularly realistic either. Finally, and I'm just setting you up here, right, by going through all the ones I don't like to get to the one I do, and I think this is a great idea, obviously. My idea, that sucks. Is that you would give guidance to lawyers saying that their advice needs to be accurate or within the bounds of objective reasonableness. You put that in the competence rule. So if you look in the competence rule, it tells you all the things of competence, but it says at the end, discipline for incompetence is only where there's gross neglect or a pattern of mistakes. So you would give lawyers guidance that this is what competence looks like, but you would limit your regulatory sanctions or discipline to those more extreme cases where there's a pattern of mistakes or gross neglect. I haven't put any downside here. That doesn't mean there isn't one, but I got to write the slides. So I think the advantage to it is it does provide guidance to lawyers for the ones who are well-intentioned but uncertain. It provides a tool to say to clients, I know you want me to give you this CYA memo, but I can't. And it ensures, though, that lawyers do understand still that they're not constantly under a hammer of potential regulatory consequences, that they can take into account their clients' interests. And it keeps the Law Society resources focused, as they generally are, on issues of misconduct as opposed to simply mistakes. I thank you very much for bearing with me through this. I do tend to speak quickly. So if your question could be just, can you tell me that part again? You wouldn't be the first people to suggest that. But as I said to begin, it's really truly an honor to be here in what I know is one of the most engaged and active bars in the country where lots of really cool things are happening. And so thank you very much for coming.
So that was great, and I sense from this crowd the desire to ask questions.
It's a hope or a sense.
So we do have the microphone up front, and we've got one of those fantastic mics. It could be like a town hall meeting, hopefully on topic.
I don't know if I really want a town hall meeting, but...
I'm trying to get with the times. I think I was talking about Oprah or something earlier. She's gone. First question? Yeah, up front.
Oh, sorry. I could just stand up. Good evening. I'm Kim Campbell, and former Minister of Justice, and Mark's former boss. Boy. There are so many issues that you've raised that are absolutely fascinating, and I could annoy you by just monopolizing this whole thing. But just one area that I wanted to raise, because I was very struck by the Schmidt case and by the discussions of the torture lawyers, and this question of creating opinions that serve a political end as opposed to necessarily reflecting the law. And there's no question the law is of varying degrees of determination. For example, when Andrews and the Law Society, British Columbia, came out in the mid-'80s, the government of Canada at that time, I think Mr. Crosby was the Justice Minister, determined that that probably had very significant implications for the way that the federal government's law and policy with respect to sexual orientation would be developed. And so it wasn't sure, and we changed policy long before the Supreme Court actually confirmed that view. But there are ways in which the courts tell us things that give us interesting answers. But a couple of things come out of this discussion that are interesting. One is that obviously lawyers have to make the distinction of when they're giving advice, when it should be as close to the determination of the law as you can, and then when they put another hat on to be advocates, because it's also fair to say, well, you're not going to win, but here's the arguments we would make if we were going to challenge this. And sometimes in the political context, you actually have people who will say, well, let's litigate it anyway, make the courts force us to do it because we don't have the political gonads to actually make this change publicly. But one of the intervening factors that is underlying both these discussions is the fact that legal opinions are not confidential anymore. And when people can get access to the legal opinion that was offered, the lawyers have to think beyond what they're giving, because people haul out these opinions to justify political decisions. And the sense that the opinion would be confidential so the lawyer could be absolutely clear on what the downsides are, with the idea being that it's still up to the political authority to make the decision whether they want to litigate or not, or defend a policy or not. And the lawyers then, wearing their advocacy hats, will give it the best shot, may win, may lose. We do know that laws get overturned, and we've seen very interesting examples of this. I mean, going back to, Plessy and Ferguson and then Brown Board of Education, I mean, courts do even reverse themselves and society changes. So all that's fair. But I think there's a particular peril that comes from the fact that legal opinions become public. And that, I think, makes the role of the lawyer, advising, particularly in a political context, even more difficult. I mean, George W. Bush's comment that we don't know what the law is creates a terrible environment to ask people for legal advice. I mean, it created a terrible environment for decision-making all around. But I think this question of whether lawyers can give advice confidentially, fully and freely, and then wear a different hat if the client decides they'd like to try and give it a shot in the courts, and you say, okay, I'm giving you my advice, but we'll do the best we can.
So a couple of comments on that. I think that the issue, as you framed it, is, and by the way, thank you for raising this point because it's central, is not so much that the opinion isn't confidential, in the sense that if the client did choose never to bring it forward, they couldn't be compelled to bring it forward. It has the legal status of confidential. However, the essential point is people use lawyers' opinions. They use them to justify what they do. And that's why this issue is such a significant one, because, of course, your client wants you to give them an opinion which will CYA. Right? It doesn't work as an opinion if all it says is, well, yeah, you could do that, but let's be clear, it's probably illegal. I mean, that is not an opinion which is helpful to any client, whether they're government or an organization or an individual. And that's why this matters so much, because in a sense, all of the incentives run the other way, especially, I think, in the political context. And I think the legal advisor, legal advocate, political advisor, when a lawyer wears all of those hats, as sometimes occurs in places like, say, the PMO, it becomes incredibly fraught and very difficult for lawyers to do it well. But I think because of that tension, the pressure on lawyers to give advice which helps clients do what they want to do regardless of legality, and that clients can use to justify their behavior, is part of the reason why you need to give lawyers this guidance. It's not easy to do it. I'm not pretending in any way that it is, but our legal system fails if lawyers don't, because ultimately it may be that people bring it out to justify the public, but the effect of that is not just that it makes the government look good as you see in the Pinkertons case, it also excuses the government from liability. It allows them to get away with it. I mean, at the end of the day, quite apart from whether John Yoo and Jay Bybee got into trouble, the reality is that it would be impossible to prosecute anyone in the government of George W. Bush, even if what they did was absolutely clearly in violation of domestic and international law, because they did it based on legal advice. And so if lawyers don't do this, we can become enablers of great wrongdoing and great illegality. We cease to have a legal system, and it becomes ruled by men. And that's the traditional term. It's not supposed to be blaming men or anything, but it is, and that's why it matters so much, and that's why I do actually get a little bit, I care about this a lot, and I think people who understand, as lawyers' roles are changing into increasingly having this function, why it's so important.
Any additional questions? Yes.
That's so good.
This may be more of a comment than a question, but you may have some observations on it. And in my role, I receive many newsletters and emails containing lawyers' views on developing legal topics. And one of the recent changes has been to reduce Fisheries Act protections. And I've been watching with some amusement and waiting for the emails and newsletters to say, hey, now you can do all kinds of things in fish-bearing streams that you didn't used to be able to do. And so have at it. But interestingly enough, that hasn't happened. I haven't received a single item like that as advice or that dialogue or communication between lawyers and clients. And so it's an interesting area where lawyers, I think, are self-governing the kinds of advice they're given, and not based on the law, but on a perception of what the law should be. So you might have some thoughts on that.
So are these, I was actually asked to repeat the question, and I for the purpose of the webcast. The question being that if you see a communication between a lawyer and a client, do sometimes lawyers underpower the client? No, I just had a follow-up question, though. Are these things that you're seeing, are they actually legal opinions, or are they things that are in the public domain that lawyers write that they think their clients will read?
And they're not legal opinions, because they all say very clearly, this is not legal advice, please call your lawyer, because that's our business model. But in a sense, they're a form of...
They're a form of creation of legal information. The skeptic in me will say, I wonder whether if those lawyers had an actual client who actually wanted to do the things that the law now permits. My guess is that some of those lawyers would actually say to their actual clients, you can do this now. And that one of the reasons why lawyers don't go out and say, hey, guess what, good news, you can go pollute, is because it doesn't look, it's not good marketing. Dean Babinski was giving me grief for my University of Calgary law marketing, but I love my law school, so I had to, I couldn't not do that. Now, though, having said that, more seriously, let's assume a hypothetical in which someone is actually giving advice to their client, which maybe constrains their client's position, but in a moral good. I actually think that's just as bad. If we have fisheries laws, I may not agree with them, despite living in Alberta. You can still, like the environment. But ultimately, we have a democratic system for enacting and creating laws, and when lawyers tell their clients they can't do things that the law lets them do, that's not right either, even if it's something that we in our right-thinking, morally conscientious, slightly left-of-center way, or whoever we are, might agree with, that's unsettling the settlement too, and that's also not acceptable. And interestingly, and this is incredibly important to note, John Yoo thinks that he did right. There's a wonderful Frontline episode called Dick Cheney's War, which is actually about the warrantless wiretapping, but it's online, and I commend it to you because it interviews a lot of these people and talks about some of the good guys. There were good guys at the OLC. Jack Goldsmith was a good guy at the OLC. And John Yoo will say, well, people who criticize me, what other alternatives do they have? What was their approach to solving this problem? And so he will claim that he was doing good in the world. He wasn't doing evil. And that people like me who criticize him are just simply unwilling to confront the actual problem. And so in a sense, I'm comfortable with the fact that the rule I'm putting forward might lead to clients being able to do things that I personally might not like or view as morally wrongful. But I think it's important that lawyers do that.
Any other questions?
Hi, I'm not sure whether there's maybe just a sliver of lawyers that this isn't really speaking to, or the difference between people who are representing clients and people who are representing litigants, particularly defense litigants, whether they are civil or criminal defense litigants, because it seems to me that in that circumstance, advising, the heart of advising is being both an advocate and an adjudicator. Because what you have to do is say to your client, this as an advocate is what could be argued, and this as a judge, as an adjudicator is what your likely outcomes are. So are lawyers who are in that circumstance doing something different than what you are describing, or are we simply the exception to it? Or do we not understand?
No, I think that means you're just doing it right. I mean, I don't need to talk to you. You shouldn't have come. Look, I mean, ideally, that's exactly what legal advice should look like, is that you say, if we go to court, and assuming that court is the ultimate place that you might end up, you say, if we go to court, here are the arguments I would make on your behalf. They are arguments that are, say, excellent, good, barely plausible. I'd make them in a pinch if that's all we've got left, right? I mean, that's exactly what advice should do. And I think one of the things that you would do for a client like that is you say, I'm going to work really hard to come up with the best case for you, because ultimately we want to go to court. But your advice might also include things like, I can actually win for you, but you can't afford to do it. It doesn't make sense. I mean, advice, good advising, and that's why I like the friendship idea, and I know it doesn't work as well for organizations, but even for organizations, I like it because it says, I want to get you where you're trying to go. I'm not just here to create roadblocks or be Dr. No or act like I'm, Judge Judy or whoever, whatever silly hat I'm wearing. I'm here to help you. And I think it does apply in organizations if your client is the Minister of Justice. You don't want to say to the Minister of Justice, well, I'm just here to judge you. You want to help that person actually achieve their goals, whether they're political or legal. But at the same time, you have to constrain that advice to avoid the situation where the person simply takes it out and uses it as a way of validating their conduct and giving them a legal result that actually the only reason they're getting it is because you were willing to put it down on paper. And so that model of both setting out what arguments are, but also assessing them in an honest way is the very best sort of advice, I think.